Well, for those of you in person, if y'all can't hear me, maybe I can't get this mic to work right now. So if you can't hear me, I'll be talking some on this one, but I'll try to talk out so y'all can hear. So anyway, though, for our second session, and again, thank you everyone who's been watching so far. We really appreciate it. Just a reminder, we'll have the recordings up probably tomorrow, but no, for sure no later than November 1. So you can go to the website to find that. But the second session today is on the topic of military policies on protest, dissent, and free speech. Your presenters today are myself, as well as Kathy Gilberd and Siri Margerin. And let me just tell you a little bit about us. I practice military law, including courts martial, administrative board, and discharge upgrade board since 2006. I'm a member of the steering committee of the Military Law Task Force and was a past chair. I'm a graduate of Oklahoma City University School of Law and the author of the book U.S. Army AWOL, a practice guide and form book. And outside of my legal work, I also work as an interfaith minister, peace activist, and I'm the editor of Humanistic Judaism magazine. Our other presenters today, Kathy Gilberd. She is a dear friend, as many of the speakers I should mention today are, but is also the executive director of the Military Law Task Force to National Lawyers Guild and a legal worker focusing on the areas of military administrative law and discharge review. She serves on the board of directors of the National GI Rights Network and is the author, with Marjorie Cohn, of Rules of Disengagement, the Politics and Honor of Military Dissent, and was a contributing author in Clark Boardman Callahan's book, Sexual Orientation and the Law. She is a frequent contributor to the MLTF's quarterly journal On Watch, as well as an editor for the publication. And finally, Siri is a respected anti-militarism activist, board member of the National GI Rights Network, Military Law Task Force Steering Committee member, and a longtime supporter, ally, collaborator, and former board member of About Face, Veterans Against the War. So thank you to Kathy and Siri for joining us today. And again, we're discussing the issues related to policies on protest, dissent, and free speech. And so to begin with, Kathy, I thought we might start with you to unpack a little bit on the primary DoD regulation that governs these policies. And then from there, we can kind of see where the conversation takes us.
Okay, and please help me not to go over. Service members are told they have no rights. When you signed a contract, you gave up all your rights. Trying to use your rights is going to get you in trouble. And they hear that over and over and over again, so that many of the people who would otherwise want to engage in dissent activities believe that they're not allowed to under military law. They also see that retaliation for dissenting activities is real, that retaliation for making a complaint is real, but retaliation simply for being a nonconformist is real and can be career-ending and can be physically dangerous. In reality, though, there are significant rights under military law to engage in free speech activity, in protests, in writing and publishing materials critical of military policy, and in being engaged in organizing around, for example, anti-war activities. The central DoD instruction on this, which is in the literature James put together for this, is DoD Instruction 1325.06. And the most important parts of that, if you're skimming, are Enclosure 3 and the definitions. I'm not going to go through all of the service regs, but I am going to suggest that people take a look at the relevant chapter of Army Regulations 600-20, because it's a little more detailed than some of the others and points to some of the problems in giving commanding officers so much discretion and authority over the policies. Now, I'm a pretty boring speaker, so let me tell you that also in the material that James put online is a wonderful memo by David Gespass on these very rules. And when you get tired of listening to me, take a look at the memo. It's marvelous. It's noteworthy that the DoD instruction is framed in the negative. So that a GI reading it is going to see that she or he cannot be participating in a demonstration under all of these circumstances. Oh, but by the way, you can participate in others. So that reading it, if you're not trained in reading regulations, can often give you a more negative view of the instruction than is appropriate. The other thing about it is that, like the service regs, it leaves a lot of discretion to the commanding officer and a lot of interpretation to the commanding officer. A rule of thumb, as you look at that enclosure 3, for any kind of protest activity, is that the service member doing it has to show that he or she is not in any way representing the military. It's necessary to separate himself or herself from the military. How? By doing this off duty, off base, out of uniform, not using any government equipment or funds, and not giving any indication in speech or a sign or anything else that you're representing the military. For a long time, nobody told the generals who go to conservative breakfast prayer meetings about this rule, although lately there have been a few suggestions that they shouldn't appear in uniform. The other thing, besides showing that you're not part of the military in your protest, is that a service member has to bear in mind all of the many offenses that could be committed by the wrong speech or the wrong activity. Just as an example or examples, it's an offense under the UCMJ to be disrespectful toward an officer or show contempt towards officials. And of course, one cannot reveal classified material, or now that's sort of been expanded to what they call operational security information, like where your ship is going tomorrow. It's illegal to incite or solicit another to engage in any kind of illegality. And of course, it's an offense to aid the enemy, which the government in many civilian cases has been defining very broadly in recent years. There are also some offenses under 18 U.S.C. One of them is advocating the overthrow of the government. Another is enticing desertion or harboring deserters. So let's leave is an offense under federal law. And it's remarkable what can be turned into one of those offenses. Saying something negative about a president can be disrespectful, it can be contempt. One has to be careful in all protest activity, and particularly in speech. For protests, for demonstrations, the instruction gives a couple of other specifics. You can't participate in a protest where there may be a breach of peace or where there is a likelihood of violence. Given modern law enforcement, it's really hard to find a demonstration where there's not a likelihood of violence. Some organizers have dealt with the danger to GIs in this by making lots of signs and statements and leaflets saying that this is a peaceful and nonviolent demonstration, and none of us are going to do anything bad. The other thing to bear in mind about the right to protest is that it exists in the United States. Overseas, US relations with foreign governments are handled through status of forces agreements, and in many cases, those prohibit off-base demonstrations. So protests, and then there's speech and writing and petitioning, where the military is still trying to work out social media policy and may not get that straightened out for some time to come, where all of the rules about not violating the UCMJ or 18 USC apply, where the off-duty, out of uniform, not representing the military also applies. There are some areas of speech that are more protected than others. Protected under 10 U.S.C. 1034, the Military Whistleblower Protection Act, especially communications to a member of Congress or to an inspector general are protected, although in recent years they've expanded it so much that many forms of complaint or protest stated to a member of the chain of command or an investigator could also be protected. And maybe you have recently read about the appeal for redress, or remember the earlier appeal for redress against the Iraq War. In these, service members collectively sent individual letters to their member of Congress stating their opposition to some U.S. military policies. They didn't do it in a petition because there was some question, still is some question, about whether a group action of signing the same petition would be dangerous under the DoD instruction and under the DoD's rules on not forming or acting in collective bargaining situations. So the appeals for redress are individualized, but at the same time had, in the first one, hundreds of service members telling their own member of Congress why they should not be involved in war. Then there's literature. Excuse me a second. Under the DoD instruction, a service member can possess one copy of just about anything. That's being eked away at a little bit under their extremism policy, which I'll get to in a minute. But generally, having one copy is legit. Having one copy of Mao Zedong's Little Red Book is theoretically legitimate. Having two copies implies distribution, and service members have been busted and treated under this instruction because of simply having several copies of the same document in their on-base workspace or room. Off-base is different, and in theory, service members can distribute. On-base, the commanding officer is allowed to grant permission for things to be distributed on base. They normally don't do that, but every once in a while it's fun to make a request to distribute something, showing that it is not contrary to good order and discipline or the morale of the unit. But it's more fun for getting turned down and then talking about that with the media. And then there's membership and participation in organizations, which has gotten a little convoluted in recent years, largely because of public attention to right-wing extremist groups recruiting in and acting in the military. The DoD instruction actually covers not only extremist groups, but also criminal gangs, which are so poorly defined that all we know is that they're gangs and they're criminals, and that one can be administratively or under the UCMJ punished for something like knowingly wearing gang colors. I don't know what gang colors are. Maybe black and white are gang colors. It's vague enough that commands have often gone after people with no basis in reality and no basis in their beliefs. The places where the regs have gotten most complicated, though, are about extremist groups and activities. And while some of this has come from public outrage over the right-wing Nazi groups in the military, I fear that a lot of it is really going to be directed against us, against our clients who are anti-war GIs or who are protesting against military racism or sexual assault, because here too the definitions and what constitutes active participation are incredibly broad. If you take a look at Section 8 of Enclosure 3 of the DoD instruction, you'll see some very broad definitions that don't make it easy to understand what is and isn't actually extremist and what is and isn't actually prohibited as active participation. The Army and the Marine Corps have just very recently updated their policies on extremist groups, but what they've really done, and this is covered, by the way, in the fall issue of our newsletter On Watch, what they've really done is required reporting of extremist activity by the command to their superiors immediately upon learning about it. So extremism includes terrorism. It includes groups that want to overthrow the government. It includes groups that want to make change in the government through non-constitutional means, whatever that means. It includes then support for organizations that have been declared terrorists by the United States, which is an ever-expanding group. And it also says that active participation in general ought to be knowing, and it ought to be more than being a mere observer. So if you're an observer at a Nazi demonstration or an anarchist demonstration, that's legitimate. If you participate in the demonstration, they can take action under the DoD instruction and the regulations for each service. How on earth do you determine where observing ends and active participation begins? Is it which sidewalk you're standing on? Is it whether or not you picked up a leaflet to look at it? This stuff is all incredibly vague and again left to commanding officers to interpret. I'm sorry, my notes are scribbled. And I think I'm going to take a look at the regulation and tell you about one of the other things that worries me. Commanding officers can take legal or administrative action when they find a violation of this regulation, but they're also allowed to take preventive action. So if a person is engaged in speech or protest activity that is clearly legal under the instruction and the service regs, the commanding officer can still investigate to see if it has gone further and can still counsel the person and can still send them for an involuntary psych evaluation. Counseling is the big thing here. Counseling means that the commanding officer or someone sits down with you, scolds you, yells at you a little bit and tells you don't do this ever again, you could get in trouble, and makes you sign the form saying that you've been told these things. The problem is that it goes into your record where it can have an effect on performance evaluations, promotions, getting desirable assignments. It's only administrative. It's something that can be career limiting or career ending, especially for officers. And it's based on entirely legal activity. As far as I know, no one has tested this yet. There haven't been many of these counselings, but I'm sort of looking for one to challenge and hope that other people will look out for it as well.
And I'll just mention that on those counseling statements, there are ways to challenge them both initially and later on. One of the things I encourage my clients in situations like that is to sign the counseling saying they received it, but there's an in place where remarks can be added, and they can assert something like, I'm exercising my rights under the Constitution and military regulations, or something like that. Just putting it in writing that they are asserting that they are expressing those rights. Having that as a starting point, I think, can be very helpful.
Okay, well, I think I would like to sort of wind up, and James, I hope that you may talk about the unionization bill, wearing uniforms, and some of the other regs.
Sure. So before we go on, just for those of you watching online, the next code you'll need, this is for session number 2. The first of the 2 codes for session number 2 is A. A is an alpha. So please write that code down. You'll need it to claim CLE credit later if you're an attorney needing credit. So anyway, continuing on, I wanted to kind of amplify a few things that Kathy talked about, but also touch on some other things. So one of the I'm going to do is I'm going to share screen for a moment, because I want to just take a moment to look at the regulation itself. And I do this because I think sometimes just getting familiar with the regulation, actually engaging with it, is quite helpful. So this is DODI 1325.06. And one of the key things in this regulation, of course, is most of it is enclosure 3. But I want to show a couple things before we get to enclosure 3. Just a couple of quick things. One being is under the references. They have no, not there. It's down a little bit. Okay, under the references, it touches on some other regulations and laws that include things like the DODI that deals with wearing of the uniform. And so one thing and it does, I don't think it's mentioned here, but also one of the federal laws dealing with electoral activism for members of the military. We won't have time to discuss those in length today, but just to say that DODI 1325.06 is not the only thing we're dealing with, but it is one of the things. Now, on down, this is in enclosure 2. Here are some more of those statutory and regulatory provisions, and also just potential charges the military could try to use to punish someone for, again, what I would argue would be often would be constitutionally protected speech. Contempt towards officials is mentioned. Bear in mind, that means anyone in the chain of command. That can include everyone from the president on down. Now, the key there is contempt. It's not disagreement. You could say, I disagree with the president. I disagree with my commander. If you call them a vulgar word, that's where it crosses the line. If you actual contempt or disrespect. Other things that they're strong, again, some of these are pretty outrageous, aiding the enemy, provoking speeches or gestures. But I mentioned this just to say that this is some of the landscape behind DODI 1325.06. But here is where we're really getting into the heart of it, is enclosure 3. And so this discusses, the first part discusses possession and distribution of printed electronic materials on post. After that, the discussion of off-post gathering places. Now, during the Vietnam War era, this was frequently used to put GI organizing projects, coffee houses, off limits. That thankfully did not happen during the latest time when we had coffee houses, during the Iraq and Afghan War. There are threats of it, but it never actually happened. Another thing is under 3, service member organization. Commanders are not authorized to recognize or to bargain with any union representing or seeking recognition to represent service members. Bear in mind, there's also a federal law that forbids organizing, unionizing, and in fact, even forbids civilians from attempting to unionize the military. That is a federal criminal statute. The next section discusses publication of personal writing matters to include websites, web blogs, and other electronic communications. A few things on this. The most important thing is if you have a client who's wanting to speak online, do things like that, the number one thing they can do is to include a note on the website, but ideally on each post or thing like that, saying the views expressed here do represent my own views alone. They do not represent the views of the Department of Defense, my military branch, or the U.S. government. Say that every single time. And my argument is if you do that, it takes a lot of the potential risk off the table. The military loves to try to go after, and again, it's selective enforcement. We all know many politicians love to put pictures themselves in military uniforms, especially reservists. I've seen this a lot, despite the fact that in most cases that's a violation of federal law as well as military regulations. They'll get away with it, but our clients will not. And so knowing this, one of the best ways to get around that is simply to state this does not represent the views of the military. Along the same lines, your client speaking to the press, and I'm not going to go into details of this, except to say that for my clients, at least, when they choose to speak to the press, I always tell them to make sure they tell the reporter, I'm speaking on my own behalf, not on behalf of the military. And I encourage my clients to record themselves saying that to the reporter. The reason being, the reporter may not put that in the story, even if you ask them to. So you need to prove you told the reporter that. So the military later says, oh, it made it look like you're speaking on the military's behalf. It's like, no, that the reporter screwed up. I have a recording to prove that I did say that to the reporter. Also in the regulation, it discussed more about on-post demonstrations and similar activities, with, for the most part, cases. For off-post demonstrations, the key things here it mentions, the times that you're prohibited from protesting. If you're on duty, if you're in a foreign country, if activities constitute a breach of law and order. D is the one that's really problematic. Violence is likely to result, or they are in uniform in violation of the uniform regulation. Now, that part about violence is likely to result, this is a real problem. I had a client, again, he has a pending case. He's been very public about his case, so I can speak about his. At that time, he was Captain Alan Kennedy. Today, he's Major Alan Kennedy, but he was during the times of protests a few years ago on issues of racial justice, he joined one of those protests in Denver, Colorado, exercising his right to do so, out of uniform, off post, all of that. But while he was at that demonstration, the police attacked the protesters, shot tear gas into the crowd. He, as a very patriotic person, was deeply offended by this. So he went home, wrote an op-ed about his experience of being tear gassed at this protest. For that, the military sought to punish him. They sought to do all kinds of things to him because they said it was that him being at this protest itself was a violation of this regulation where violence is likely to result. And so we had to take it to court, sue in federal court, and it's for the most part is resolved. Still some issues still outstanding, but our argument is that a service member cannot be expected to be a fortune teller. They can't tell if violence is likely to result. But moreover, in this case, the government was the violent actors. There's no violence at all in this particular demonstration towards the police, towards anyone else. The violence was all one way, from the police at the protesters. So I bring all this up to say that there's some complicated issues here, and you have to be ready that if a client is wanting to take free speech actions, they do need to understand that there is some degree of risk, and that the good news is, though, it can be pushed back on. Finally, there's discussion in this regulation about addressing of grievances. The key things there is you cannot do collective grievances, but you are allowed to express your grievances to members of Congress. It mentions the Inspector General, among other officials. There are channels, but acting outside the channels, there could be problems. Finally, the extremist activities regulations are deeply, deeply problematic. And there's a lot of, well, I'll just read what it says, defines extremist activities. It says, advocating or engaging in unlawful force, unlawful violence, or other illegal means to deprive individuals of their rights under the Constitution, the laws, etc. Okay, that's very reasonable. Other issues gets a little more complicated. Advocating or engaging in unlawful force or violence to achieve goals that are political, religious, discriminatory, or ideological in nature. Key words there is unlawful force or violence. C, advocating, engaging in, or supporting terrorism within the United States or abroad. Terrorism, as we know, can be interpreted many different ways. D, advocating, engaging in, or supporting the overthrow of the government of the U.S. or any political subdivision, yada, yada, by force or by violence, or seeking to alter the form of these governments by unconstitutional or other unlawful means, such as sedition. Now, one of the challenging things here is how does nonviolent civil disobedience fit into this? Could participating in a sit-in protest, nonviolent sit-in protest, be called an unconstitutional or unlawful means? I think arguably yes. Deeply, deeply disturbing. It also mentions advocating or encouraging military, civilian, or contractor personnel within the DoD or the U.S. Coast Guard to violate the laws of the United States, yada, 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 for the purpose of disrupting military activities, subversion, or personally undertaking the same. This is a real problem. For instance, encouraging troops to say, do not fight in an illegal war. You should resist. One interpretation of this statute is that would violate that, saying it that clearly. Finally, F, advocating widespread unlawful discrimination based on race, color, national origin, religion, sex, including pregnancy, gender identity, or sexual orientation. This is the interesting thing. This is one of the provisions that I wish they would enforce. They often do not. That members of the military may at times, particularly when it comes to gender identity and sexual orientation. Unfortunately, there's the issue of selective enforcement. But anyway, I wanted to just to take a moment to show this because I think it's helpful to see a little bit of what we're dealing with in this regulation. The main thing here is jumping down to enclosure 3 is, also, I should have mentioned we're going, it does mention more details about what active participation looks like in an extremist organization, some of the details of that. So I'm going to go, and again, also what Kathy mentioned earlier about preventative activities by the command is right here. I will mention just in passing briefly, and this is really another topic for another seminar, would be to discuss the issue of compulsory mental health evaluation, some of the problems that come up with that. One other thing I wanted to mention in passing, though, are some of the creative ways that service members have found around regulations to get their message out there, but in a way that stays within the bounds. And that's why I want to talk about the appeal for redress. And this afternoon, one of our speakers, Jonathan Hutto, will speak more about the original appeal for redress from the previous times of war. But I'm going to share just briefly about the appeal for redress version 2. And this is a project that's organized by Veterans for Peace, but along with the Center on Conscience and War, the MLTF, sponsor of this CLE, and of course, About Face Veterans Against the War. And the idea was that to enable service members to be able to choose a letter that's already been gone through legal review. In other words, lawyers have looked at this and have said, we believe that this letter would not violate existing federal law. To allow the service member to pick one of these letters, to send it that goes to their member of Congress, expressing concern about the U.S. government's funding of the Israeli government's continued war on the people of Palestine. We also give an option for service members who want to write their own letter to send it to get legal review first before sending it. But the idea here is that members of Congress can, by law, engage in protected communication. They can speak a right to the member of Congress. And that right is not only protected by the DoD, but it's also protected by federal law and by the U.S. Constitution's First Amendment. The right to seek to talk to your member of Congress, to write your member of Congress, is protected by law. The military doesn't like this. They try to rein it in many ways. But the important thing here is that it is protected communication. And so one of the creative ways about this is finding a way to do it in a collective manner without violating the collective bargaining laws. And so this is why the appeal for redress, I think, is a really powerful tool in that. So anyway, I think we're going to move on now. I'm going to invite Siri to speak next, and then we'll have some time for some questions and answers along the way. So Siri, and also before we go on, let me give you the second code for this block of time. Your code is J. J is in Juliet. J, that's your second code for this hour. Again, just a reminder, after this workshop is done, for those of you watching online, you will get an email and I'll ask for the codes for the hours you watched so you can get your credit. So Siri, you're up.
Hey, so I'm Siri and I am not a lawyer or a legal worker like Kathy or whatever you prefer. I am an activist and organizer, and that's the view I'm here to represent. And the first thing that, and I really appreciate the fact that Kathy and James exist and the folks from the last panel and the ones to follow, because I depend on you guys to keep an eye on the the monster that we share the room with at all times. So the reality is, do you remember what is it? Anyway, that you cannot use the master's tools to dismantle the master's house? This is something that every time I hear someone saying that, I think, but the truth is we are all treated like tools that are like the master's tools ourselves. And certainly if you're in the military, I thought it was very interesting to hear Peter saying that being in the military is like being in prison, just as a meta, as a reality check. Okay. And so here we are. And the truth is that the military is bigger than an elephant in the room, and it is very powerful. And every time we come up with a trick, it's a joke that we'll write a paper about something and then there will be changes to the paper before we even get a chance to publish it. We are always coming from behind and picking away at things. But these issues are actually a matter of life and death. It's completely serious. It's not something that you get into for the glory of it all, because if there's one thing that our clients and our community of military veterans know, is that war is not glorious, and neither is the battle that we're engaged in. It's not, it's small, dedicated work, and we have to do it with a huge amount of faith because it's taking forever. So we have, as an example of it being a matter of life and death, what the action of Aaron Bushnell, who in uniform did go and set himself on fire in front of, I'm not sure exactly what it was in front of, in fact, at this moment, but because I think his sense was that there was not a way short of physically catching on fire to get the attention of people and to say what he needed to say. And the power of it came from saying it in his uniform, because there had been just the week before someone who was not in uniform who had done a similar thing and was absolutely overlooked in the press. So nobody can retaliate against Aaron because he took care of all that. But we have a new generation of people who have been radicalized by what's happening in Gaza, who are coming at their consciences and what the tools are that they can use to make themselves be heard, to assuage their consciences, and to protect themselves from, well, there's no protecting yourself from moral injury. I think that is that comes with the territory, and I'm beginning to think that there's no escaping it in the world that we know right now. But that's the preface to all this, and I'm not here to give you rules and regulations and tell you things. That I'm here to encourage you to join MLTF, to support MLTF, to support About Face, to support the appeal to redress, which is an amazing tool and a wonderful thing, but it is really hard, really, really hard for service members, as certainly for civilians, to actually get that in front of people who are serving in the military. And that's our struggle, is how to do these things. And it's easier. I mean, my story is that I spent my time here working both with truth and recruitment groups to try to convince people not to join the military, to support through speaking on the GI rights, being on the GI rights hotline and counseling service members, and then for supporting with everything I've got about FACE, which was folks who had been there, done that, and were sincerely trying to change things. So it was kind of because I really, and having watched this unfold over the last, let's say, just 20 years of Iraq and Afghanistan, and now what's happening now, and seen the way, number one, the people who come to be conscientious objectors are, most of them exclaim in the beginning, nobody ever told me that this was a possibility. That's right. The military does not inform people about what their rights are. They are much more likely to say, you have no rights. And they don't just say that, they act it out. And there's no equality between how they can fudge the rules and how they can tell people things that aren't true, and what the other side, our side, is able to do. So, and the amount of power and pressure and money and resources on one side, and the fact that there is so much moral weight on the other side, is extremely unequal. And that's what people are struggling against. So I think that what we need to be thinking about is, how can we support these people, and how can we find them, or how can we be found, is more to the point. How can we make ourselves findable so that that there is support there? Because every generation when people are making these moral decisions, some of them are making them on the battlefield, like Adam Delgado, who was in Iraq when he realized that he was becoming a conscientious objector, and he mentioned it to his command, and they sent him galloping across the landscape with no protection in his battle vest. Everybody else was wearing their flak jackets, and he had nothing. So that's and he was also isolated in his company, which is what often happens. Is people, they see that something's going wrong, they have this eruption in their conscience, or their politics. It isn't always conscientious objection. It could also just be pure political fury, and there are ways to isolate them in their unit so they feel like they're the only one, and then they may have the courage to keep pushing forward, and they may end up getting just not saying anything until they get out, and carrying a terrible load of moral injury. During the Iraq and Afghanistan war, and I'm not going to go back to Vietnam or any of that, but people did come back and go to Canada. There were resistors in Canada. There were resistors who, I see Steve Collier is here. He's going to be speaking later about his relationship with Stephen Funk, who was the first public resistor to the war in Iraq. There's people like Kevin Benderman, who was in Iraq, came back, and comes from a military family stretching back generation upon generation. From Alabama, everybody went in the military. It was just the way it was done. And he found his eyes opening while he was there, came back and said, I don't want to do this anymore, and got charged, went to military court. There's the list of people who have done that. I don't know if you want to hear it, but we've got it. And if you want more, ask questions in the discussion. But the point is that folks do find their way, and they're finding their way under difficult circumstances. All kinds of, Alexis Hutchinson is another one. She was had just had a baby. Her child was 8 months old. She had nobody to leave her child with, and she was was deployed to Afghanistan, I think, and they took her child away from her, and it took legal representation to make sure that she was able to come home. But all of that, even though it isn't logical, and it probably isn't legal, and it certainly isn't moral what the military is doing, people are railroaded down that, and they're told, no, this is the way it goes. You can't do anything about it. You don't have any power, and people are forced into that. I mean, on the hotline, people would tell tales of folks sort of being dragged down the runway to get on the plane and scrambling to go back. No, I'm trying to say no here. So it's our obligation to support them, and that means to make ourselves findable, as I said, and to be there for what they need. And mostly that will amount to things like material support, legal support, of course, that's who we're talking to here, but also historical support, bringing information to people, and being a community. It is not asking us to step in and lead these folks. They are so capable of leading themselves because of what they have been through. And it is not, it's extremely courageous, and it's extremely important for us to be there. So I guess that's what I have to say. And let's take these next 12 minutes for questions.
I'll mention just briefly one thing that before we move on to questions, and that is that often from the lawyer standpoint, and sometimes also in other roles as well, a lot of times our job is to help our clients to creatively find a way to engage with their activism in and managing the risk. For some of them, they may know very much, I'm okay with breaking the law within certain boundaries. To me, my job as a lawyer then is to make sure my client is fully informed of the risk they're getting into. It's one thing for someone to get in trouble because they know it's coming. It's a calculated risk. It's another thing when someone takes a risk and it has implications they didn't understand. And so that's part of it. But also sometimes it's a matter of helping our clients to creatively thinking about options. And I'm thinking about several times I've been consulted with clients who want to wear their uniform or part of their uniform during a protest. And my encouragement to them has been, well, you could do that and you might get away with it. I know people who have. They can also hammer you, and here's the different ways they can hammer you. If you're okay with that risk, fine, that's your choice. I'm not telling you should do it. I'm not breaking the law. If you choose to anyway, knowing that that's fine. But I also will say, if you want to identify yourself as a member of the military, but do not want to get in trouble, you might want to consider doing something else, such as during decade or so back, one of the things many of my clients would do would be wearing a T-shirt from Iraq Veterans Against the War. And we had some really fun experiences at Fort Hood arguing with some commanders there and individual units about whether it's lawful to wear an IVAW T-shirt on post but off duty. There's a lot of things like that you might want to consider, but whether it's wearing a T-shirt, whether it's doing something else, where the risk specifically comes in is wearing a uniform or parts of a uniform. So sometimes our job can be to help to be creative and help our clients to find a way that does fit what they're needing. So we officially are on break, but I want to go ahead and open it up for questions for the next 10 minutes before our next session gets going and for some discussion. So, but again, if you need to take a break, that's fine. We'll be starting our next session in 9 minutes. But in the meantime, let's go ahead and have some conversation questions. If you want to put it in the chat, that's fine. If you want to unmute yourself and say it out loud, that's fine too. And for those of you in person too, same thing. If you have any questions, let us know. And if not, I guess we will get started again in about 8 minutes or so. So also, I'll just mention for our next session, it is on the topic of defending resistors at courts martial. The presenters for that will be Steve Collier and myself. So that will start at 11 o'clock Central, about 8-9 minutes. So